Hello, everyone. Thanks for joining. I'm a lawyer in the commercial technology team at Bristow's LLP, a private practice law firm in London in the UK that specialises in technology and life sciences law. I've got the fantastic privilege today of talking to you about regulatory trends in AI. And I'm going to start by surveying the various governance and compliance options available now for AI. Think about kind of what's coming down the pipeline in terms of new legislation. I'm going to talk a bit about the GDPR and the EU's AI Act in particular. So let's get going. This is an image created by a generative AI art model. We asked it to produce an image showing the landscape of future artificial intelligence regulation, and this is what it came up with. And it did what AI is supposed to do, and it generated an output that was both surprising and helpful, which is depict a city under construction. You can see the cranes and so on dotted about. And that fits because what I'm going to talk about now are laws and other regulatory measures that in the main aren't here yet, but are, if you like, rapidly taking shape. But before we start looking at the regulatory landscape, I think it's helpful at the outset to take a step back and consider the more fundamental question of why regulate AI at all? What is it about AI that makes it so different from other forms of technology that we might need laws or other forms of regulatory intervention dedicated to it? Hopefully, many of you will be familiar with the concepts on the slide here. These are the generally recognized ethical and legal challenges associated with AI. I'll run through them quickly. So autonomy, it's the ability of machine learning algorithmic models to make their own decisions when undertaking tasks to a level that match or exceed the capabilities of humans, at least in narrow domains. That is at the heart of all of this. If we're going to delegate important decisions to machines, to have machines make decisions and do stuff, we need to be as sure as we can that those decisions lead to outcomes that are safe and ethical. Opacity is that complex machine learning algorithms are so technically sophisticated, it can be impossible to understand how they've produced particular outputs. This is the so-called black box effect. This is a problem generally, speaking for transparency purposes, i.e. if you want to explain to people how the algorithm works. And more specifically, if the algorithm causes harm, it makes it very difficult to reverse engineer how or why the model produced the problematic output. In terms of bias, as I expect you know, machine learning models are trained on large data sets. The data sets will invariably contain various biases, and the model may amplify biases in the data set and generate outputs that are discriminatory, toxic, and or biased towards marginal groups. And on privacy, the ability of machine learning to infer or generate new personal information about someone from other data it is exposed to, in particular, is a new kind of problem for privacy law. And I think it's also worth acknowledging some of the softer factors that are driving activity in the AI policy space at the moment. Firstly is the speed and scale of disruption that AI is bringing or promises to bring to many sectors. Second, there is a kind of apprehension or uncertainty about the technical capabilities of machine learning, where it's all heading, driven often by a forgivable misunderstanding of highly sophisticated and complex technology. And thirdly, connected with that, I think is a hype around AI. You know, it's a technology of the moment. It gets a lot of media airtime, and I don't think that anyone, including policymakers, are immune to that. So given the potential risks relating to AI, what are the different kinds of measures that have been adopted to mitigate or control them, you know, over the last few years? So starting right at the softer end of the spectrum, AI ethics principles are statements of the ethical principles that are supposed to apply when creating new AI technology. They're pretty ubiquitous. All sorts of organizations have them. The OECDs are considered the most influential and important. A huge amount of work has often gone into these, but from a legal point of view, they don't unfortunately carry much weight in isolation. They don't measure or assess compliance. They're not enforceable. Worse, they could mask inaction. What is useful is that the majority of them boil down to the same core principles that seek to address the issues we looked at a moment ago: safety, responsibility, transparency, fairness, privacy. So I think it's fair to say that there is consensus about what the positive outcomes are that we want from AI, what good AI looks like. The challenge is how to achieve that. And in fact, there is a huge amount of ongoing work, particularly within the major technology companies, to develop tools to help solve the ethical challenges of AI at a technical and operational level. Much of this work is dedicated to transparency and explainability, not just of the models themselves, but also the data sets they're trained on, and also implementing tools that detect and reduce bias. It's still a very new field. I don't think that anyone is arguing that there is an equation or quantitative method that's going to solve fairness, for example. And designing tools like these involves trade-offs and difficult qualitative judgments to try and find an acceptable outcome. But it seems to me inevitable that tools like these will end up moving from being voluntarily adopted in the private sector to being part of the wider regulatory landscape for AI over time. Then there's a huge volume of guidance, frameworks, and other resources published by regulators and other governmental agencies. Generally speaking, these kinds of documents aren't legally binding. What I've listed on the slide are some of the more detailed ones that have been issued that I'm aware of, so it's inevitably slightly more UK and EU-centric. That's not to say there's plenty of examples from the US and elsewhere. Just picking on a few, the UK Data Protection Regulatory Agency, the Information Commissioner's Office, or ICO, has excellent guidance on explainability, which is a great example. It's very detailed and practical, has separate sections for compliance teams, technical teams, and senior management. Singapore's AI Verify toolkit includes technical testing software, similar to those, some of the tools on the preceding slide. And the FDA's and the UK's medicines and healthcare regulatory agencies' ongoing work in the context of AI as medical devices is a good example of regulators working within a vertical sector on issues specific to a narrow domain. Then there are technical standards for AI. So these are standards developed and approved by a recognized standardization development organization, or SDO, like ISO, IEC, which many of you would have heard of. The most important SDOs are CEN-CENELEC and ETSI. There is a lot of activity developing standards for AI within all these SDOs, including ones that tackle non-technical topics like bias and transparency. CEN-CENELEC in particular has been tasked by the European Commission with developing standards to use to meet the technical requirements under the EU's AI Act, which I'll discuss a bit later. But we aren't yet anywhere near having a set of generally accepted standards or indeed consensus around which SDO standards to use. But it's fair to say there is a lot of excitement about the promise that technical standards hold, which is to use them as a way of, if you like, cutting through the complexity of regulating AI and ending up in a place where you can point to compliance with a technical standard as a way of achieving compliance with legal requirements. And finally, some actual law. My criteria for inclusion in this list is that the law has to be focused on or have a section devoted to AI. The key thing that I want to emphasize now is that as we speak, only two of these are actually law. One is the GDPR's provisions on automated processing, which I'll discuss in a minute. The other is China's law on algorithmic recommendations. All the rest are still at different stages in the legislative process in their respective jurisdictions, all still in the pipeline. So to kind of try to think more broadly about trends across all these different kinds of measures, what if we try to map all these different approaches onto a graph with hard law at the top and soft law measures at the bottom, sector-specific measures on the left, and generally applicable measures on the right? What would it look like? Well, I think, personal view, the current state is something like this. Lots of horizontal ethics and regulatory measures in the bottom right, operational tools specific to particular organizations over on the left, standards, and a lot of regulatory activity, again, that is domain specific, so also on the left, bottom left of the quadrant there, but not much law. So the top fields are fairly empty. But where are we headed? So I think the future state is shaping up to be something like this. So lots of law coming down the track and lots happening in the standard space, and an even higher volume of guidance and other soft regulatory measures and toolkits in specific sectors on the left there. And of the laws coming down the pipeline, by far the most significant one, in my view, is the European Union's AI Act. I'm going to spend a bit of time unpacking that in a few minutes. But before I do that, I want to look at arguably the most influential and important piece of legislation in place today that regulates AI, and that's the EU's General Data Protection Regulation, or GDPR. I want you to think of the GDPR as a kind of sleeping giant of AI legislation. Anyone providing a product or service using AI that processes personal data that is in scope of the GDPR will have to comply with it. It has specific restrictions on profiling and automated decision making. And many of its other provisions are engaged by and highly relevant to AI use cases. And in fact, very similar concepts have been in EU data protection law since the 1990s, but were kind of stuck in a dusty corner of that legislation and almost never discussed. But the giant's starting to wake now, if you like, as the GDPR's latent potential as a regulatory instrument of AI is starting to be realized, with some interesting cases starting to come through. So let's kind of just look at the detail for a few minutes, because as we'll see, these provisions have proven to be quite influential. Article 22 of the GDPR is a restriction on decisions based solely on automated processing that have a legal or similarly significant effect on an individual. And there's a separate, kind of slightly related concept of profiling, but I want to concentrate on Article 22 and ADM. Of course, many AI use cases involving personal data won't be either profiling or decisions based solely on automated processing, but many will be. And a few kind of comments on the text here as you read it. Although not immediately apparent from the wording, Article 22 is interpreted in the regulatory guidance as a general prohibition, with some limited exceptions I'll come to in a moment. So it is a ban, not merely a right for individuals to object. In terms of kind of examples, so decisions based solely on automated processing, which produce legal effects, are those that affect legal rights or status. For example, denial of a social benefit granted by law, or refusal of admission to a country. Examples given of decisions that have similarly significant effects are those that affect someone's financial circumstances, such as their credit eligibility, decisions that affect access to health services, and decisions that affect someone's access to education. So and those are examples. That's not a closed finite list. And for a decision not to be based solely on automated decision making. The human involvement in the decision can't be fabricated or be some kind of token gesture. It must be meaningful oversight, and the person must have the authority to change the decision. And then there are 3 exceptions to this ban on decisions based solely on automated processing, which produce legal or similar significant effects on individuals, to give it its full moniker. So these 3 exceptions are where it's necessary for the performance of entering into a contract, where it's authorized by law, or based on explicit consent of the individual concerned. And then there's a slightly narrower range of exceptions for sensitive special category personal data like health data, which I'm not going to go into here. And then where any of the exceptions are used, the GDPR mandates that suitable measures are implemented to safeguard the individual's rights. Then there are transparency requirements, so the individuals must be provided meaningful information about the logic involved, for example. Then there are specific rights that the individuals whose data has been processed have, including a right to object. A data protection impact assessment must be completed prior to the start of the processing, and a data protection officer appointed. And some of the same obligations apply to profiling. So I've set it all out here on the slide so you can see just how far-reaching Article 22 is. You know, the number of things that you have to do to comply with it. It's quite something. But going beyond automated decision making in Article 22 in the GDPR, you know, many of the GDPR's other provisions will also be highly relevant for any AI that processes personal data. And I'll kind of just mention a couple here. So DPIAs will be required not just for automated decision making under Article 22, but also for any automated decision making, even where a human does make the final decision. And regulatory guidance suggests that a DPIA will be required in many circumstances where personal data is processed by AI or machine learning, and there's a kind of decision tree to go through in the guidance, which I won't unpack here. And then just another on fairness. One of the GDPR's fundamental principles in Article 5 is that personal data shall be processed fairly. Does this mean that a controller operating an algorithmic model that produces biased outputs and is discriminatory is in breach of the GDPR? You know, the GDPR's kind of potential as a way of getting at bias and discrimination in AI, I think, you know, is a very interesting area that hasn't really been tested in the courts yet. And as I said, automated decision making also, you know, does really squarely count as a regulatory trend, thanks to the influence of EU privacy law. ADM and profiling in some form, though rarely, I think, quite as comprehensive as, if you like, the full package that appears in the GDPR. You know, it does appear in other privacy legislation. So, for example, in Brazil, South Africa, and China all have ADM or profiling like provisions. And it's also very influential in US state law, privacy legislation. So there are ADM-inspired laws coming to force later this year in New York, California, Colorado, Connecticut, and bills kind of in process in Michigan, New Jersey, and Pennsylvania. And you know, I'm aware of similar laws in other states too. So the idea that privacy law is going to regulate automated decisions that have a significant effect on people, I think, is a very strong theme in terms of regulatory trends. So if the GDPR is a sleeping giant that's stirring awake, then the EU's AI Act is more like a blazing comet that's kind of coming towards us in the night sky, right? It's got everyone's attention. It's going to have a big impact, but we don't quite know yet where it's going to land or when it's going to land. It's the first EU law specifically devoted to AI. It's very ambitious. It's going to have a lot of influence globally. For AI systems in scope, it will impose a regulatory framework that's similar to what happens in the product safety world, but tailored to AI products and services. Like the GDPR, it has extraterritorial scope. So AI developers selling AI software into the EU from the US or the UK, for example, will still have to comply with it. It also has a GDPR-style high penalty and enforcement regime, fines of 30 million euros or 6% of global annual turnover, whichever is higher, for the most serious breaches. In terms of timings, it's taking a long time to move through the legislative process in Brussels. The draft act was published by the Commission nearly 2 years ago. And right now, we're still waiting for the EU Parliament to finalise their amended text of the Act, to then start the process of negotiating towards the final published text with the Council and the European Commission in what's referred to as a trilogue process. So we're not yet, although the Act was published 2 years ago, we're not even yet at the point where the three institutions in Brussels are actually haggling and negotiating over that final text. We expect that to start probably by Easter this year. The expectation is that process will finish by the end of this year or early next year, which would then mean that the actual law applies in 2026. So how does the AI Act work? The Act regulates AI that causes harm, either because it poses a potential risk of death or injury, or because it could threaten fundamental rights and freedoms. So the scope of the regulation or Act covers 3 areas. Firstly, it completely bans a small number of relatively niche uses of AI. Secondly, it classifies a pretty long list of specific other uses of AI as high risk. For the high risk use cases, the Act imposes a regime of mandatory technical and transparency requirements, and also subjects them to a product safety style conformity assessment regime with approval by notified bodies, CE marking and post-market surveillance. It also has some transparency obligations that target any use of AI that could either be mistaken for a human being, like chatbots, or that creates content that deceives or mimics human beings, like deepfakes. All other AI is out of scope, and AI systems developed or used exclusively for military purposes are expressly out of scope. In practice, almost all of the articles of the Act relate to high-risk AI. So I would suggest that the key question that most commercial lawyers, product teams, and so on will want to ask of the Act is whether any particular AI product or service will be classified as high risk or not. So I want to look at some detail actually at the high risk categorization. And there are 2 different ways that the Act categorizes an AI system as high risk. The first is on this slide. So this is all about product safety. So the harm it's trying to mitigate is health and safety risk. So people being injured or killed by AI products or services. And the first criteria here is the text at the top of the slide. So AI systems in scope are those that are types of product or safety components of products that are already required to undergo a conformity assessment by an accredited notified body, as they're called, under existing EU product safety legislation. So a key principle of that legislative framework, is that manufacturers or importers are permitted to self-certify less risky types of products, whereas inherently riskier products, for example, gas appliances, an independent assessment must be made by a regulatory agency called a notified body. The second criteria is that the product itself must be legislated under one of a number of sector-specific product safety laws that fall within what's referred to in the EU kind of product safety world as the new legislative framework. And the relevant product types in question are listed in the AI Act, and they're in green on the slide here. And this means that some products and sectors that you might assume would be caught by the Act aren't at all, notably vehicles and aviation. So those are all in red there on the right of the slide. So that's a big scope exclusion that may not be intuitive to you unless you're schooled in the intricacies of EU product safety law. The second way that the AI Act categorizes products as high risk is much simpler. It has a list of specific use cases within certain sectors that are deemed high risk. And the potential harm the Act is trying to mitigate here is, generally speaking, an adverse impact on human rights or freedoms. So I've put the list up on the slide here. Most of the areas are relatively niche, orientated either to utility infrastructure, law enforcement, or the public sector, for example, immigration control and assessment of eligibility for welfare benefits. It's also important to understand that this list is understandably one of the areas that is subject to the most intense debate and negotiation as the draft Act is being discussed in Brussels. There is a push to add additional sectors and use cases. For example, AI used for risk assessment and for pricing in the insurance sector, and also critical digital infrastructure. And some amendments proposed by the EU Parliament add health and pharmaceutical sectors and use cases as well. There are also voices who kind of want the list to be more mutable, with the Commission able to add new use cases yearly rather than every 5 years, as in the published draft. Others who want additional criteria for high risk. So this whole area is, in more state of flux, understandably, than other bits of the Act. So if this is an area of focus for you, the AI Act, my recommendation would be that you keep an eye on this list, which is in Annex 3 of the regulation, and the process around it, which is in Articles 7 and 73. And so just keep an eye on that as the Act kind of moves through the trilogue process, through the rest of this year. And then at the heart of the Act is a set of technical requirements tailored specifically to the development of AI-powered software. So these are the requirements that developers of high-risk AI will have to comply with. So these are one of the first, and I think definitely the most comprehensive attempt to formulate in legislation technical requirements for the AI development and governance lifecycle anywhere in the world. And my guess is that these will prove to be very influential. Whilst many of them are things that many developers of AI products will already be doing. Others, for example, having a risk management system in place, will be new and of course present a significant cost burden, at least for developers who aren't currently operating in a tightly regulated sector like software as medical devices, for example. So For many software developers building AI products or services who will never have had to comply with anything like a product safety regime before, the AI Act, I think, is going to mean an absolutely profound shift in the way they develop, market, and operate their software if they're building anything that is deemed high risk under the Act. These technical requirements are also going to play an important role in the development of the technical standards for AI. So from a product safety legislation point of view, these requirements are the essential requirements, as it's referred to in the legislation, which the Commission can then use to mandate a standards development organisation to develop standards for. And critically, products that meet the harmonised standard will be presumed to comply with the essential requirements. So comply with the standard and you comply with the law. As I said earlier, this has a real potential to kind of simplify the whole process of compliance with the Act. The Commission has formally requested that the EU Standards Development Organisation, CENLEC, develop and adopt harmonised standards in relation to the AI Act, these technical requirements on screen, by the 31st of January 2025. So they're already working on those. And technical standards have the potential to play a hugely significant role in the regulation of AI, not just in relation to the Act, but also more generally. This is a list of some of the notable AI standards under development at ISO, IEC, and other international SDOs. Of these, I would highlight ISO IEC 42001, which is a management system standard developed specifically for AI, rather like ISO 27001 in cybersecurity. The standard was out for public consultation over the autumn and winter last year, and it is due to be published later this year. So I think that is a great one to keep an eye on. I would also, if you're interested in this area and you don't know about the Turing Institute's AI Standards Hub, then I would strongly recommend that you Google it and go and check it out. So this is a UK-based organisation that set up a really fantastic live database and tracking tool, which is really doing an excellent job of keeping tabs on the development of different AI standards all over the world, and you can sign up and get alerts and so on. It's fantastic. So the Turing Institute's AI Standards Hub in the UK, if you're interested in AI standards, do check it out. And so I'm just going to do a little bit of compare and contrast on some other legislation before wrapping up. So the UK government is taking a very different, an interestingly different approach to that of the EU. So the UK's proposals for early proposals for the regulation of AI were published last summer. And they read almost as if someone in Whitehall in London had looked across a channel at the AI Act in Brussels and decided to take the opposite approach in every conceivable respect. So instead of a single blockbuster law with a new regulator, existing UK regulatory agencies will be responsible for looking after AI in their respective domains. It's an expressly pro-innovation approach. So only tangible actual risks will lead to regulatory action in order to avoid inadvertently discouraging innovation through unnecessary law, which was a criticism of the EU's approach. There will be a set of principles, not technical requirements, but principles at the heart of the framework to try and ensure a coherent approach across different sectors. And the UK government will start from the position of encouraging regulators to take a light touch approach. So it's pretty clear that the UK government sees an opportunity in AI policy to exploit a Brexit dividend and create an innovation-friendly environment for AI developers in the UK when compared to the EU. And there is a lot to be said for a more pragmatic and flexible approach, particularly given the very different types and levels of risk that AI poses in different sectors. What hasn't quite yet been explained is how the UK regime, though, will accommodate the awkward fact that many UK developers, because many of them will be developing high-risk AI, will have to comply with the EU's AI Act anyway, which could mean overlapping requirements for anyone in the UK developing high-risk AI, as defined in the EU legislation. In the EU legislation. And in terms of other AI laws, interestingly, the White House's proposed AI Bill of Rights has some similarities to the UK's approach in that it proposes a central set of principles but devolves responsibility to sector regulators. The Canadian AI and Data Act is clearly inspired by the EU Act. It regulates high impact AI, though it leaves the criteria of how to determine high impact to regulations that haven't been published yet. And it isn't as comprehensive a text as the EU's law. The US Algorithmic Accountability Act and New York's ADT law both focus on decisions made by automated decisions that significantly affect individuals, so inspired by the GDPR's ADM provisions, but not quite as fulsome as the GDPR's approach. So I'd say I think the macro trend in AI law right now, if there is one, is for law that either focuses on decisions that significantly affect individuals made by automated systems, or that regulates AI that is classified as high risk in one way or another. And I think the other trend is that it's going to be very interesting to see whether a sector-specific approach becomes the norm, or whether we'll see more horizontal legislation like the EU's AI Act. In terms of practical recommendations, here's a few. I mean, if you're in a sector that is heavily regulated already, then I think it's fair to assume you will also have AI-specific laws or mandatory guidance within 3 to 5 years from now. Clearly, whether a product or service is classified as high risk under the AI Act is going to be very important. So, I would suggest if you're in that space or you conceivably might be, it's important to keep track of the progress of the legislation and start planning ahead if you're likely to be caught. And obviously, any product or service that makes significant decisions about people is also going to be regulated, one way or another. And I think there's going to be a hell of a job, frankly, to do if you are in more than one of those spaces, as I think there is absolutely a very real risk of overlapping and mutually inconsistent regulatory requirements applying to some use cases and sectors. But even for those products or services where I think for none of the above apply, the fact is we are starting the process of shifting towards a world where the market expectation I would predict is going to be that some kind of good or responsible practice has been used in the AI development life cycle. So I think all lawyers, compliance people, and product managers and so on need to start thinking ahead to what their AI governance and quality control procedures should look like, as many are already doing. So thank you. That's the end of the presentation. If you have really burning questions that I haven't answered now, then please feel free to send me an email, and I will. I'll get back to you and try to answer them for you. But I think I'm going to say goodbye now and wrap it up. And thank you, so much for joining. I've really enjoyed it. I hope you've got something from it. Thank you.